Hello and welcome everybody. I am Sana Parvez, your legal expert for Hitbullseye, and in today's video we shall be discussing Kaushal Kishore versus the state of Uttar Pradesh. This is a very recent and a very important judgment, which is a constitutional bench judgment. That is, it has been given by the five judges of the Supreme Court, and most of it is unanimous. If you will see, most of it is a unanimous verdict, but at some points Justice B.V. Nagaratna has dissented. We shall discuss about the judgment, and we shall also discuss about the judgment in the context of Article 19 of the Constitution as well as constitutional torts. So first of all, in order to be able to understand the judgment, the points in issue in the judgment, we have to understand the facts of the case. The facts of the case were as such that there was a family which was traveling from one state to the other for the death right ceremonies of certain person, certain distant family member. While they were on their way, their car was basically robbed, and also a minor family member was gang raped, and there were charges pressed against the prosecutors, the perpetrators of the crime for gang rape as well as under the POCSO Act. In pursuance of the same, politician Azam Khan made a statement stating that all of the whole gang rape and the offences against the POCSO Act and even the robbery for that matter was nothing but a political conspiracy. Now, this statement of Azam Khan hurt the sentiments of the family. They said that firstly they stated two things. Firstly, that him being a politician of such a high stature, they now do no longer feel safe having the trial conducted in that very state, because they are apprehending that there are some political forces, or there are going to be some political influences because of which the justice is not going to be served to their family. And secondly, the statement that was made by this person was essentially a constitutional tort. So, in the light of the same, we shall understand what a constitutional tort is. In pursuance of these grievances, the family filed a writ criminal petition, and in this criminal petition, a three-member bench was formed of the of the Supreme Court, and an amicus curiae was appointed. Amicus curiae is essentially a friend of the court who helps the court in the legal matters, and he is, for all practical purposes, a lawyer itself. So an amicus curiae was appointed, and three-member bench was constituted. The three-member bench did not frame any issues as such, but it sent out, or it forwarded the case to the larger bench, which is the constitutional bench. The constitutional bench consisted of it was led by Justice Abdul Nazir. It further constituted of B.R. Gavai, Justice Subramaniam, Justice A.S. Bopanna, and Justice B.V. Nagaratna. So, as we discussed earlier, the judgment is unanimous for all the five, except for a couple of points which was dissented by Justice B.V. Nagaratna. Now, let us have a look at the issues that were framed by the constitutional bench. The first issue was that are the grounds specified under Article 19(2) in relation to which reasonable restrictions on the rights of the or to free speech can be imposed by law exhaustive, or can additional grounds be put in that Article 19 Clause 2? Second was, can a fundamental right under Article 19 or 21 of the Constitution of India claimed other than against the state or its instrumentalities, meaning to say, can it also be claimed against a private person as well, or only against the state and its instrumentalities? The third issue in question was whether the state is under a duty to affirmatively protect the rights of the citizens under Article 21 of the Constitution of India, even against a threat, not just even against a violation to the liberty, but also against a threat to the violation of liberty of citizens as such. Then Uh, the next point was, can a statement made by a minister traceable to any affairs of the state or protecting of the government be attributed vicariously to the government, especially in the view of collective responsibility principle? And the last one, whether a statement made by a minister which is inconsistent with part 3 of the constitution, that is, if a statement is made by the minister which is inconsistent with the fundamental rights of constitute as a violation of such constitutional right and is actionable as a constitutional tort or not. Coming to the first issue, whether the reasonable restrictions given under Article 19, Clause 2 are exhaustive, or can more restrictions be added to the list? First of all, Article 19 is freedom of certain miscellaneous freedoms have been given, including freedom of right to free speech, expression, assembly, association, movement, trade, residence, etc. So here, categorically, if we talk about freedom, because here the case is concerned with freedom of speech and expression, since it was an expression made by a certain politician, then if we talk about Article 19, Clause 2, it gives out certain reasonable restrictions in which the freedoms that have been given under Article 19, Clause 1 can be restricted, or limited up to only a certain or a certain reasonable extent. So now, with regards to freedom of speech and expression, these reasonable restrictions are 9. So to say, sovereignty and integrity of India, the security of the state, friendly relations with the foreign state, public order, decency, morality, and in relation to contempt of the court, defamation, and incitement of any offense. Here, the Supreme Court stated that the purpose of the Constituent Assembly at the time of framing of these reasonable restrictions was to basically protect the fundamental rights of the persons and not to protect the reasonable restrictions. So therefore, reasonable restrictions are limited. The court further envisaged the court further examined a list of reasonable restrictions or exceptions which are given under the different parts of the constitution as well as the different parts of IPC as well. And it came to the conclusion that this list is exhaustive and no other grounds can be added to the same. Now, second, can a fundamental right under Article 19 or 21 of the Constitution be claimed be claimed against any other person than the state or instrumentalities of the state? Meaning to say that if we have to dichotomize this issue, we dichotomize this issue in two ways. Firstly, what is directed against the state and what is spelled over in hearing in every individual without reference to the state. And the other dichotomy is with respect to citizens and persons. So we all know that the fundamental rights are applicable against there are certain fundamental rights which are applicable against citizens as well as non-citizens equally, and there are certain fundamental rights which are available only against the citizens, or only available to the citizens rather. These rights can be Article 15, 16, 19, 26, 29, and 30. They are only available to the citizens and not the non-citizens. And the second dichotomy in this regard is who are they applicable against? In a similar fashion, the articles are divided on this thing. There are certain articles which are applicable against everybody, and there are certain articles, all parties, that is the individual parties as well as the state, and there are certain articles which are only applicable against the state and its instrumentalities and nobody else. So when an article is applicable against only the state and nobody else, it is called a vertical application. And when it is applicable against this state as well as the individual persons, it is the horizontal application. In this, a reiteration was made by something that was earlier said by Justice Vivian Bose, uh, putting it in a poetic language in Sri Krishnan versus the state of Madras. It stated that for a moment, Set aside the pettifogging of the law and forget the nonce of all the learned disputations between and or may or must. Let us understand what was given in the spirit of the Constitution and not the letter of the Constitution. According to the spirit of the Constitution, Article 19 and 21 were worded as such that a fundamental right under Article 19 and 21 can be enforced against persons other than the state or its instruments. Uh, However, Justice B.V. Nagaratna in this case basically dissented from the opinion of the other four judges, and she stated that only habeas corpus is a writ that can be applied against private persons as well, and no other writ can be applied against private persons. Coming to the third issue, whether the state is under a duty to affirmatively protect the rights of the citizens of under Article 21 of the Constitution, even against a threat to the liberty of the citizens by the acts or omissions of another citizen or private agency. Here, the Supreme Court noted that the idea under Article 21 of the Constitution. It does not say that the state shall not deprive any person of its right to life and liberty. It rather says that no person shall be deprived of his life and liberty uh, by any except for any means other than the procedure established by law. So, in this regard, the court stated that earlier the meaning of right to life was very narrow. Earlier, at the time of the making of the constitution, the framers of the constitution thought that the right to life meant only at that point of time, it meant only the right to life of animal existence and not a right to life with dignity. However, as we progressed, as we made more advancement in the societies, it became clear to us as well as the Supreme Court as the level of quality of living increased. It was made clear that right to life is also right to life with dignity. So, when the word life was understood to mean only physical existence, the deprivation of the same was generally conceived to be possible only by the state, except in the cases where someone had committed any law, any offense against the law. In Justice K.S. Puttaswamy judgment, also a judgment of 2017, this court made it clear that it is a right which protects the inner sphere of individuals from interference by both the state as well as the non-state actors. The state is thusly under a duty to affirmatively protect its citizens against not only the state instrumentalities if they are infringing the rights, but also against the non-state instrumentalities, one, and secondly, against actual violations of these fundamental rights, and also against a threat to such violations as well. In the fourth issue essentially was that can a statement made by a minister traceable to any affairs of the state or for protecting the government be attributed vicariously to the government itself, especially in the view of collective responsibility. So now the idea of collective responsibility is given under Article 75 Clause 3 and Article 164 Clause 2 uh, of the Constitution. Article 75 with respect to the Parliament and Article 164 with respect to the state legislatures. Collective responsibility doctrine states that the Council of Ministers is collectively, for all practical purposes, for the conduct of it. It's responsible directly to the Lok Sabha and the Legislative Assembly, and it is accountable for all its actions to that. Here, if we explain the rationale, if we try to understand the rationale behind the doctrine of collective responsibility, the object The object is to vicariously hold responsible the ministerial office for such act or of the others as referable to the collective volition, so that even if an individual may be not personally responsible for it, yet he will be deemed to be responsible for it or share that responsibility. So the idea is that the ministers should have that amount of onus, they should feel that amount of onus while making any kind of a statement, that we are not only making these kind of statements in our own capacity, but also we are making these kind of statements as a representative of the government who has selected us, or the government where we are standing. In this regard, the Supreme Court basically tried to differentiate it between two things. One, which are statements which are made in personal capacity, and statements which are made in official capacity. The statements made in personal capacity, for these statements, the government cannot be vicariously held liable. However, if the statements are made in the official capacity, the government can be held vicariously liable. However, Justice B.V. Nagaratna differed from this position, and she stated that the statements which are made in the personal capacity, if they can be traced back to any affairs of the state, in that case, if they're talking about any kind of political conspiracy, or if they're talking about any such other affairs of the state, in that case, they shall be traceable to the government, and the government shall be held vicariously liable for such irresponsible or such malicious statements. In the last issue which was discussed in this case, whether a statement by a minister inconsistent with the rights of the citizens under Part 3, that is the fundamental rights of the Constitution, constituted violation of the constitutional rights and is actionable as constitutional tort or not. So, in order to understand this issue, first of all, we need to understand what is a constitutional tort. A tort, essentially, if we talk about not a constitutional tort, but a tort is a civil wrong which is not a breach of duty under contract, and not a breach of trust as well. So, a tort is not criminal wrong, it is a civil wrong, it is not under a contract, it is not under a trust. So, if we take this civil wrong and add two more attributes to it. One attribute, if it is made by any state or its instrumentalities or its agencies. And second, if it is causing infringement of any fundamental rights of a certain person. Then this tort becomes a constitutional tort. So, the question here is whether this kind of a statement, which we are discussing in the particular case, whether this kind of a statement by a minister which is inconsistent, not violated of article of chapter 3 of the constitution, but is merely inconsistent with the fundamental rights, whether that kind of a statement constitutes a constitutional tort or not. Here, first of all, trying to understand the liability of the state, it was understood in two cases. There are two landmark cases in this regard: State of Rajasthan versus Vidyavati, and Kasturi Lal versus the state of Uttar Pradesh. In State of Rajasthan versus Vidyavati, it was held that the tortious actions of a person, individual person who is a government agent or a government servant, cannot be attributed to the government. However, contrary to this, Kasturi Lal versus State of Uttar Pradesh, the court stated that liability of the state is equal to liability of any employer, because the state is employing the government servants, so the liability is going to be the same. Here, the constitutional bench essentially stated that a mere statement made by a minister which is inconsistent with the rights of the citizens given to him under the articles chapter 3 of the constitution, the fundamental rights, may not constitute as violation of the constitutional rights and become actionable as constitutional tort. Any act, but if as a consequence of such a statement, any act or omission or commission is done by the officers resulting in harm or loss to the person, then the same may be attributed as a constitutional tort. So here they're saying that merely if a minister is making a statement which is not sitting well with the fundamental rights, then that does not become a constitutional tort per se, and that has no liability. The person making such a statement will incur no liability as such. However, if due to that speech any further loss or any special loss, so to say, is incurred by the victim, then that victim can approach to the court, and that particular thing is going to be considered a constitutional tort. At this point also, Justice B.V. Nagaratna begged to differ, and she stated that this is something that hate speech is a menace in the country and it needs to be checked, and therefore even a mere statement made by a minister, even if it is not resulting in any special damages, even that should amount to constitutional tort. So I hope you have understood all the five issues of the judgment. These were the five main issues on which the judgment was given. If you have any doubts regarding the video, please comment. And if you like the video, please like, share, and subscribe. Thank you.